Mr. Elliott.
We have 3 cases left. The first 2 are important. First one is going to be post-prudential.
Well, don't bother with the third then.
Well, the first one is amply weird, which I'm going to deal with quicker, as it were. The first 2 are particularly important.
I tease you. Okay.
Post-prudential closure notice, because it is the latest word on, well, conforming construction from this court and what we say is certainty, sort of the unforeseen. And the other case is going to be Fleming, which is important not because we say it decides this case, we say quite the opposite, but it's important because it's relied on, it's central to the other side's case. Post-prudential closure notices, tab 76. We're going to be reading the judgment of Lady Justice Falk, with whom both members of the court agreed, one of whom was Sir Lancelot Henderson of Prudential and FII fame. This case is a follow-on from the decisions about portfolio investments. I did say you would have a good feel of this by the end. So shareholdings of less than 10%. The potential breach of EU law is the one we've already looked at, that portfolio dividends did not get relief from tax at the nominal rate paid in the foreign jurisdiction. And that is summarised in paragraph 3 by Lady Justice Falk on 2402. This case is about procedure, because as set out at paragraph 4, from April the 1st, 2010, there was an amendment to the claims procedure which ousted certain common law claims in favour of statutory claims. And they have a time limit, which we'll see later as 6 years. Paragraph 10 is the issues. I'm not going to ask you to read all of them. We can skip though to 15 on 2406, where Lady Justice Falk sort of attempts to provide some themes. 2 overarching points. The first is the extent to which the interpretation of the procedural regime should be approached in a manner which ensures the taxpayers secure all benefits which they would have been entitled under an EU law compliant tax regime, even though they were not aware of the precise nature of their rights before the time limits for making claims expired, and as a result made claims which must be maintained are not effective. Paragraph 21, for your reference, is a summary of the history of the proceedings, much of which we've actually gone through already, including the 2 judgments of the CJU. Paragraph 22, so these claims are statutory claims made by taxpayers. The problem they have is, as we saw, that there's a conforming construction applied to the double tax relief provisions. So the outcome is the taxpayers can get their entitlement, remove the restriction, or make the legislature when proportionate, by then being able to claim a double tax relief credit. But that entitlement only became apparent after all the litigation summarised in 21. And that's why it's stated, in particular, even when the taxpayers were aware that they might have claims based on a breach of EU law, there was a substantial period when it was possible that any breach might be addressed in another way. Paragraph 24, it's common ground in that case that the double tax relief needs to be claimed, or you need to do something. And paragraph 25, the ordinary time limit is now 6 years after the accounting period. So when the time limit expired for these taxpayers, they didn't know that they ought to make a double tax relief claim, because that had not yet been established. What were the taxpayers arguing therefore? It's 26. The essence of ground 1 is that their complaints, the effect of the Upper Tribunal's decision is a retrospective invalidation of the taxpayers' claim for credit at the FNR. The taxpayers have made every conceivable statutory claim and had clearly asserted their EU law rights. They had done so at a time when the existence and nature of the breach of EU law, and in particular the appropriate remedy, were unclear, and in circumstances where domestic law made no provision for credit at the FNR. Nevertheless, the statutory procedures that applied as if Section 790 had always provided a credit of the FNR, even though the taxpayers could not have anticipated it. Taxpayers maintain this is wrong, both EU law and domestic law. You can see immediately the analogy with these submissions being made in this case. And why is that a problem, say the taxpayers? They say it's wrong because of a mix of principle of effectiveness and legal certainty. Legal certainty in particular you see set out at paragraph 36 on page 2413. But in the tailpiece to 36, we set out principle of certainty. In this context, it's hard to see that this adds the principle of effectiveness. As can be seen from the CJU's reading in Visciano, the issue there related to potential breach of the principle caused by lack of legal certainty. That is the core of the taxpayer's complaint in this case as well. So this case is about legal certainty. The complaint, in essence, is that the remedy with which they've been provided is not actually compliant with EU law because it breaches legal certainty. Because they did not know of their specific right, and therefore they didn't bring their claims. These taxpayers are in a worse position, in a sense, because there was a time limit, it's expired, they're never going to get their remedy, they're not going to get their tax credits. Quite similar to the complaint of the taxpayers in this case, saying that the Upper Tribunal's conforming construction does not vindicate their EU law rights. But as I'm going to come on later and say, is it actually realistic to say that the taxpayers in our case have not had a vindication of their EU law rights, given they have actually had their deferral? Post-prudential is a fortiori. They're never going to get their credits. So, question, if a taxpayer's specific EU law right is only revealed by subsequent litigation after a period of considerable uncertainty and multiple references to the CJU, does that mean that any remedy they are given through the conforming construction breaches legal certainty? Answer from this court, no. Please may I ask you to read paragraphs 39 to 42 of the judgment. In a sense, we're not seeing anything that we haven't already seen in the case law. We're just seeing it in a very particular, extreme situation. So paragraph 40, confirmation that decisions of the CJU are necessarily retrospective and the normal declaratory theory of judicial decision-making. Paragraph 41, conformity construction is also inevitably retrospective, reference to Vodafone, reference to IDT. Then there's the reference to Lord Sumption, the relevant bit of FII paragraph 176, so we say that has been endorsed by this court. Paragraph 43 addresses effectiveness. Paragraph 44, there is nothing in the EU law principles relied on by the taxpayers, whether equivalent to effectiveness, legal certainty or judicial protection, that mandates a different approach. There is no principled basis for distinction of the kind taxpayers try to draw between having no knowledge that there's been an infringement and having some imperfect knowledge. This is quite an important sentence. Provided that a time limit under national law is reasonable and fixed in advance, it will be valid, whatever the state of the knowledge of the claimant, to have a reasonably they acted. That wording, fixed in advance, we will see again in Fleming. because there are special circumstances that apply to time limits. They have to be fixed in advance. That is the whole basis of Fleming. And it was picked up by Lord Sumption when he said there were special circumstances, and he referred to Grundig and MS. Paragraph 48, Mr. Remler sought to argue the difficulties arose not from EU law, but from the way in which the conforming interpretation was adopted. However, the conforming interpretation did no more than reflect the substantive EU law, the effect the underlying tax credit was both available and should be granted. The Court of Appeal said there's no complaint about the conforming construction, because all it did was reflect the EU law rights. Paragraph 49, argument about the development of the litigation. And there's the sentence beginning at, it's the last 3 lines. While HMRC may not have accepted a claim for DTR, i.e. back at the time, if one had been made, it would have been open to the claimants to assert the validity and effectiveness of the claim through an appeals process. So you may need to litigate to vindicate your EU law rights. It doesn't matter. The revenue might say no. In effect, the taxpayer's position and the conforming interpretation required to remedy the breach goes beyond. So the conforming construction they begin is not enough because it does not vindicate their rights in such a way that they say they need to be not disadvantaged. I see no basis for that in the case law. And 51 was the reference to impact, which of course is also relied upon by the appellants in this case. I see nothing here that assists the taxpayer's case. The CJU referred to general principles of legal certainty, but their existence is not in dispute. More personally, the CJU emphasised the requirement to give full effect to EU law. That is what the courts of this jurisdiction have done with the conforming interpretation. And that rejection of reliance on general EU law principles applies equally in this case. So we submit PPCN, co-prudential, contains clear statements about legal certainty. Lady Justice Falk states that it applies to time limits, and we'll pick that up in a moment with Fleming, which have to be known in advance. But the mere fact that conforming constructions are retrospective and that taxpayers do not know that they have the rights or what the precise extent of their rights are, or that the revenue might fight them tooth and nail every step of the way, does not offend legal certainty. You say that is a very powerful statement, particularly in the context where the taxpayers had basically missed the boat, because their EU law rights were never going to be vindicated in a realistic sense. But the court says, well, actually, your EU rights have been vindicated, because that's what the legislation is deemed to have said all along. I'm afraid you just didn't make the right claim. You didn't make it in time. Fleming. Tab 45. We'll take a little bit of time on Fleming, because it is not the most straightforward of cases. If I may start with a summary. Fleming is driven by the context and what EU law required in that case in respect of time limits. What had happened was legislation had been introduced in 1996 and 97, retrospectively removing taxpayers' rights to deduct their claims for input tax by introducing a 3-year time limit that had not been there in respect of accrued rights. That was then subject to a reference to the ECJ in Marks and Spencer. Marks and Spencer was the specific reference from the UK. And what the Court of Justice said is you can introduce a time limit, but it has to be fixed in advance. Otherwise, it breaches the principle of effectiveness. the taxpayers and the revenue agreed that the offending legislation had to be disapplied. The revenue asked the House of Lords, this is in 2008, so 10 years later, through disapplication to read in a transitional period. So that the new time limit came into effect. They were aiming for, I think one of the arguments is 6 months, 12 months. Lord Walker goes for 3 years in the end. And the majority of the House of Lords held that was not possible in the circumstances of that case because it did not fix the breach of EU law. Because for a court in 2008 to introduce a transitional period which ran from 1997 to a date that had already passed is not fixing a time limit in advance. So the proposed solution still breached EU law because of the specific requirement of EU law in that case. The background is more concisely set out, if I may, in the Court of Appeals judgments. If we could just go back to tab 44. It's easiest to see it here. It's page 901, paragraph 6. So this is all about Regulation 29. And what the Court of Appeal does is, in square brackets, it sets out what was added. So you had a provision for claiming your input tax deduction. There was no time limit in Regulation 29. 1A, in square brackets, is brought in to impose a 3-year time limit. Paragraph 7, final few lines, the change was actually made in December 1996, but with retrospective effect to July 1996, so it went backwards. The Court of Appeal in M&S referred the question for preliminary ruling, and you'll see that at paragraph 8, but the critical thing that comes back is the internal quotation from the Court of Justice at 38 and 39. And it is the final few words of 39. However, in order to serve their purpose of ensuring legal certainty, limitation periods must be fixed in advance. So the Court of Justice told the UK court what EU law required in that case. So now if we turn back to the House of Lords, we will see that theme fixed in advance picked up. And so we're back to tab 45, page 946. No, we're going to 946. So just so you're aware, paragraph 46 sets out what the two claims were. Mr. Fleming and Condé Nast have made claims. One of them made their claim in 2000, one made their claim in 2003, both after the time limit. The summary of the judgments, and I'm going to give you the summary, if I may, both in terms of outcome and reasoning. All of the law lords grant Mr. Fleming's claim. 4 of them allow Condé Nast's claim, Lord Walker doesn't. That only tells you so much. We say more important is, in terms of the reasoning, there is a centrist majority of 3. And they are Lord Neuberger, because Lord Hope agrees with him, reference, that's paragraph 1, and Lord Carswell also agrees with him, that's paragraph 75, and they held that whilst in principle it may be possible to introduce a transitional provision through disapplication, they couldn't on the facts of that case. We'll see that. Then there's 2 who, in terms of reasoning, are at the extremes. Lord Walker said not only was it possible, but he did it. And that's why his transitional provision, Mr. Fleming was inside it and Condé Nast wasn't. That's why he gets a split decision. Lord Scott is at the other extreme. He's saying you can never introduce a transition provision. So there is a centrist majority in terms of reasoning. So if we start then with Lord Neuberger, paragraph, it's page 956, paragraph 79. Lord Neuberger summarises the principles at paragraph 79 and note C in particular coming from M&S. The time limits must be fixed in advance. And these are principles from Marks and Spencer and another case called Grundig, but Marks and Spencer is the case referred by the UK in respect of this legislation. And D, where a time limit is retrospective, there must be a transitional provision. Paragraph 80, second sentence. The issue is whether it is open to the court to disapply the retrospective limitation for a limited period. Paragraph 84, the commissioners were arguing for a period of 6 to 12 months for a transitional period, which would run from 1997 to 1998. Noted at paragraph 85, well, on that basis, it came into force in 1997. People with accrued rights to claim would have had to put in their claims by 1998 at the latest. So one reaches this position. The vice in the regulation is that it contains no transitional period to enable persons with accrued rights to make their claims. And the remedy on the Commissioner's case is that there is to be a period of disapplication whose existence would be unknown to any reasonably advised person with an accrued right. This would mean that the supposed remedy for the failure to accord a transition ruling would be little more than hypothetical. In other words, from the perspective of community law, I consider the Commissioner's solution to the problem fails on the very ground that the problem exists, namely that it breaches the principle of effectiveness and legal expectation. That is what is being said. The proposal of a court in 2008 telling taxpayers that they had a time limit which had expired 10 years ago was still contrary to EU law because it still failed to give them advance notice. You see that in particular at paragraph 88. The point seems to me to represent a second reason for rejecting the primary case. As I've mentioned, a valid limitation period must, in order to satisfy community law, be fixed in advance. In my judgment, the same principle must, as lateral logic, apply to transitional period. After all, they serve the same function. If that's right, the period of disapplication envisaged in the last sentence of Grundig must comply with that principle. Again, it serves precisely the same purpose, namely to enable a person to make a claim to know within what period they have to bring their claims. Otherwise, where no transitional period has been provided for, persons with accrued rights will not know or be able to find out with any confidence when they have to make their claims by. In other words, community law requirement of legal certainty would not be met on the Commission's primary contention. So Lord Neuberger is saying, EU law has told us in that particular situation precisely what's required. You need to fix a time limit in advance. Unsurprisingly, Lord Neuberger, sitting in 2008, is not willing to read retrospectively the time limit that expired 10 years earlier in 1998, because it fails on exactly the same ground. It's not fixed in advance. But your reference, paragraph 108, paragraph 108 is where Lord Neuberger says, I've heard no detailed argument as to what circumstances a court could commence a period of disapplication. I'm prepared to accept in an appropriate case a decision of the UK court could have that effect. But in the circumstance of this case, because of the difficulty ensuring adequate communication, i.e. notice, of a decision of the court which might be affected other than by the commissioners, the ease and speed at which they grant, I would have thought it unnecessary and inappropriate. And 3 of the other law lords agree with him on that point that in principle it may be possible. We know Lord Walker agrees because he does it. Lord Carswell is 955, page 995. I will confess to we've scratched our head a little bit about Lord Carswell's judgment, because at paragraph 74, he says, in respect to Mr. Fleming's claim, I agree entirely with Lord Walker's reasons and conclusions. But then he says at 75, in relation to Condé Nast, I agree with Lord Hope and Lord Neuberger. And then he goes on to agree in more detail. I must confess I find it very difficult to see, given Lord Walker's adopted completely inconsistent reasoning to everyone else, how he can agree with if you read it as I agree with the outcome of Lord Walker's judgment, that would be consistent. But anyway, he certainly agrees with Lord Hope and Lord Neuberger, and in particular at 77. For the reasons given by Lord Hope and Lord Neuberger, I do not consider this as a determinative issue. I agree with them that it is for Parliament and Commissioners who must disseminate the information sufficiently to all value-added taxpayers to introduce prospectively an adequate transitional period which will apply to all claims for deductions. This was not done and indeed has not yet been effected. So the reference to dissemination of Parliament is the need to give advance notice. And Lord Hope, at 929, paragraph 1, he reads, we say incorporates what we've already seen from Lord Neuberger's. He says he agrees for the reasons he gives, but then, of course, adds his own way of putting it. Paragraph 9, so yesterday, the day before, there was a discussion about paragraphs 8 and 9, which one applies. It's paragraph 9 that applies. Sufficient notice of these transitional arrangements must be given to ensure that the exercise of those accrued rights is not rendered virtually impossible or excessively difficult. Otherwise, there will be a breach of effectiveness. I would not rule out the possibility in a suitable case of the court reaching its own decision as to what would be a reasonable time limit, but I don't think it can be done in this case. And they said there is a gap in the legislation which is unfilled. The infringement of EU law cannot be said to be comparatively minor. The primary responsibility is giving a clear indication to taxpayers as to where they stood without regard to the making of claims, despite retrospective expenditure, is for the legislature and the executive. And then paragraph 11, to be compatible with EU law, taxpayers are entitled to be told in advance of any transitional arrangements. And that is what the wording of Marks and Spencer. In paragraph 12, for these reasons, and for those explained more fully by Lord Neuberger, I would hold the period has not yet begun. So they find there is no the transitional period has not yet begun, which means that everyone's claims are in time. He also says at 12, it's for Parliament or the Commissioners if they choose to do so by means of an announcement or to introduce prospectively an adequate transitional period. So in more concise terms, Lord Hope is applying the same reasoning as Lord Neuberger. Any transitional period has to be fixed in advance to be consistent with the principle of effectiveness.
But they're also, he's making that point, but he's also saying, as I understand it, it's sort of a constitutional point to do with knowledge of the law, that it has to be done either by Parliament, i.e. legislation, or an announcement by the commissioners. So as I read that, they're saying a court ruling on this particular point wouldn't do the job.
He seems to be saying that if
and that seems to be also what Lord Neuberger was saying.
He seems to be saying in the particular situation of time limit, so about this, if the court announced, the House of Lords had said, well, your time limit's done, you've got a year, really that is a job for the commissioners as well. But the reason, so that is a constitutional reason, in relation to time limits specifically. But the particular issue, we say the theme that runs through, at least in parallel, is that the solution being offered by the commissioners in that case did not solve the breach. It could not solve the breach. And I'll say this now. So we've already seen in FII Lord Sumption say special considerations apply in a case of this nature on time limits. And we also saw Lady Justice Falk say the same thing, that time limits need to be fixed in advance. So what we have is a particular category of case where legal certainty or effectiveness do require adequate knowledge. You bring in all these points about whether a reasonably informed taxpayer would understand it. But it is a special category of case. I should add, that leaves Lord Scott. He is the only law lord who says that courts should not ever apply transitional periods. But on that narrower view of disapplication, he is in a minority of one. And we submit, as we submitted below, that no weight can be put on this particular reason. So Fleming is fundamentally different. 3 features. Firstly, the Court of Justice said that where you've retrospectively taken away a taxpayer's rights, any transitional period has to be fixed in advance. That's what EU law required. And that can't be done by a court in 2008, reading back to 1998. And of course, there was the concern that the taxpayers would miss out on what EU law entitled them to, albeit that is not always going to mean that it can't be done. because that could be said also to be the situation for Lady Justice Falk. But our case is not about, there's no CJU saying you need to have adequate notice or anything to be fixed in advance. All the EU law right is immediate payment. And there's no retrospective act here done by the UK Parliament in curtailing rights or time limits. Indeed, Advocate General Cocotte, knowing exactly what the UK legislation said at the time, not containing a deferral right, we submit is essentially inviting this court to consider whether it can do a conforming construction in paragraph 60. It's to say it's never been part of the CJU jurisprudence in this area that the deferral period needs to be known in advance. We'll do it very briefly with Ampli. Okay. Tab 70. Ampli award is about UK VAT legislation and excise duty legislation. And what the commissioners were arguing was that the UK VAT legislation was too generous, that it had not implemented the VAT directive appropriately. The effect being that they wanted to impose an additional tax charge, which was not present in the UK regime. The UK regime being because sales of alcohol goods held in warehouses in another member state were treated as being supplied outside the UK. If you've got a supply outside the UK, then for that you don't have tax in the UK. That was the critical feature of UK, and that's set out for your reference. It's paragraph 28, which we'll look at. It's 2201. It was section 18, and it's a combination of 3, 4, and 6, which defines a warehouse as being a warehouse in any member state. And that meant that VAT and excise duty arose at the same point. Page 2218. HMRC were arguing this could be fixed. They offered some conforming constructions. That's paragraph 98. Offered 3 options. And the court says no. And the main reason is that the court cannot evaluate the consequences, because you'll see, and the full reading, it's 101 down to 106, is the court keeps on saying, what are the consequences of this going to be? HMRC can't tell us. And that's at the end of, sorry, it's in 101, last few lines. Regulation 41, which seems to have been disapplied, although HMRC did not suggest how this might be done, what would take its place. I do need to grapple with what you might say is a literal reading of what Lord Justice Lewison is saying about clear words and interpretation directly contrary to the words. The answer to the question this morning about what was cited to him is Danske is cited. British Gas, as far as we can say, has not been cited in this case, which we looked at this morning about contra legem and how Danske has been applied by the domestic courts. We say Lord Justice Lewison is not going against 20 years of the principles on conforming construction. When he says this goes against the wording, when you read as a whole, he is deciding that a cardinal feature of this legislation is that VAT and excise duty go together. It's expressly stated that's a policy choice that's been taken by Parliament. And we can't go against it. That is what he means. He cannot be saying, we submit, that it's impossible for a court to read in words. Of course that would be wrong, given everything that we've seen. And particularly in 108, there's discussions of unforeseen ramifications. That is what we say about Ampli. When you read it as a whole, it disputes about unforeseen ramifications and go against a cardinal feature, which was that the legislating's deliberate decision to align excise duty liability and VAT liability. And that was a decision of Parliament. It stated, well, there must be reasons for that, whatever they might be, that's for Parliament to decide. So to conclude on legal certainty, our conclusion is, firstly, contra legem means inconsistent with the grain. You have our submission on that. In this legislation is in accordance with the grain. In relation to legal certainty and retrospectivity, the ordinary principles are conforming constructions are inherently retrospective. It does not matter that the taxpayer might not have been able to identify the precise nature of their EU law rights. That's Lord Sumption and BPCN. And it does not matter that they might have to litigate to vindicate their rights. There is a special set of cases where there is a right, an EU law right, to know your entitlement in advance, and that relates to vindication at time limits. We saw that Lord Sumption 152 calling it a special situation. We're not that case, we're not looking at the time limit, so the ordinary principles apply. Then briefly there's the point about the appellants, whether they're entitled to a choice. As Mr. Bell submitted, choice in this context means a right to defer. And if you agree with the Upper Tribunal, these taxpayers did have a right, they did have a choice, because of course the conforming interpretation has always existed. It was there in the legislation, whether they knew it or not. That is the nature of a retrospective conforming interpretation. That's the short way of dealing with this. Like the claimants in PPCN, who did not know about their specific right to bring their claim for a credit of double tax relief, that is a consequence of retrospective conforming construction. But actually, these taxpayers, of course, are not in the same situation of Fleming or PPCN. In each of those cases, the taxpayers did not take the relevant step and were going to miss out on their entitlement. But the entitlement here is not to pay the tax. How does one take advantage of that entitlement? How do you exercise your choice? Well, answer, you don't pay the tax. And that's what these taxpayers did. They didn't pay the tax. And HMRC have taken no steps to enforce payment. They've taken steps to assess. They haven't sought to collect. There's been no attempt to get a judgment debt or anything like that. And then the taxpayers have resisted assessment because they say they get an exemption. And thus far they've been unsuccessful. But whilst all that's been going on, they have not paid. Well, Redevco have now finally paid, but Panayi still haven't. Redevco paid, I think, 2 or 3 years ago, long after the 5 years.
Sorry, when did you say Redevco paid?
2022.
2022, thank you.
Exercising, so it's difficult on a principled or realistic basis to see how their rights can be considered hypothetical when it has been completely achieved, i.e. their EU law entitlement to defer payment. Exercising a choice is not to pay, that's what they did. And at that point I'm winding up. I thought of going through the Upper Tribunal decision, but effectively I would simply be taking you through the paragraphs and the reasoning to say it's all correct, including distinguishing each case effectively for the reasons I've given you and the way in which they formulate the construction. In terms of the grounds of Redevco, I've dealt with the cases they rely upon and the main point of legal certainty and policy choices. The only points they have left are interest that we already discussed this morning. And then the only point left, of course, is their factual argument, which is they had a legitimate expectation, taken short. They can't succeed on the facts because of the finding in paragraph 26. The more fundamental point, they cannot claim a different outcome to, say, Panayi because of their facts. They went to one barrister, Panayi may have gone to a different person. Conforming interpretation is a legal analysis. The facts of your case cannot affect the conforming interpretation a particular taxpayer gets, no more than it can affect the particular interpretation you get under domestic law. So the same result must apply for both cases. And that doesn't seem harsh on the fact of this case because they have deferred. Certainly it's no harsher than the consequences in something like PPCM. They're never going to defer it. The only other point I was going to say was, obviously there's a written case, and we respond to that written case, and of course we adopt all the points in the skeleton argument, and hand back to Mr. Fell.
Thank you. Mr. Fell.
My ladies, my lord, I'm going to be able to take these points quite quickly. So we're now we're well into block 3 of the submission. So what I will do is I will respond specifically, it's actually going to be quite quick, to the points the grounds which Panayi specifically have advanced, and then I will explain our respondent's notice point, which is block 4 of our submissions. Just quickly before I do that, there was a point which arose yesterday in response to a question from Lord Justice Miles about the contents of the reference which went up to the CJU, and we checked that overnight, and Mr. Elliott was quite correct that it doesn't refer in terms to section 59B of the TMA, which is the payment obligation. All it does is say that it says that the payment is due on the 31st of January, but doesn't cite the specific statute which imposes that payment obligation. And for your notes, that's, if you look in the core bundle, tab 21, pages 353 and 354, you'll find that. So dealing specifically with Panayi's grounds, ground 1 is that a conforming interpretation is impossible for the reasons which Mr. Elliott has just essentially gone through, so all the points around legal certainty, retrospectivity and such like. Obviously he's already dealt with those very fulsomely, so I'm not going to repeat his submissions. Ground 2 is that the conforming interpretation adopted by the Upper Tribunal doesn't remedy the breach of EU law because of its retrospective nature, and in circumstances where what EU law confers is the full-blooded entitlement to a choice, which we discussed in the course of my Block 1 submissions yesterday. And so our answer to that is that EU law, for the reasons I gave yesterday in my Block 1 submissions, doesn't confer the sort of full-blooded entitlement which is referred to by my friend Mr. Johnson. Instead, it simply confers a legal right or option to deferment. So that's the response to ground 2. Ground 3 of Panayi's grounds is the contention that the Upper Tribunal adopted the wrong conforming construction and should instead have adopted a conforming construction of deferral until realisation of the asset. And we know in particular from Mr. Johnson's helpful submissions yesterday, that what they mean by deferral until realisation is more than just deferral of payment, because that doesn't help them. That what they mean in fact is, well, they refer to it as deferral of liability, and what they mean by that is deferral of the tax charge, i.e. the tax charge doesn't kick in until realisation, and then they have an alternative possible way of doing it in which the tax charge is deferred and quantification is still done by reference to the market price as at the date of exit. Now, I've got 5 points in relation to that ground. My first point is that it goes much further than is necessary to remedy the breach of EU law. So when we went through the cases on exit taxes, it's very clear that the CJU's concern is specifically with payment, and so the Court of Justice makes it very clear that there's not a justification. There is a justification and no justification problem, and no proportionality problem in itself with an exit tax which applies at exit and is quantified by reference to the market value at exit. So changing that aspect of the legislation isn't necessary in order to cure the problem. So that's my first point. My second point, a related point, is that...
You can see that under that could actually be very important, because if one imagines a company going into liquidation, it may be that the charge has accrued, and it would then be a liability in the liquidation of the company. Whereas if the charge is actually postponed until realisation, it wouldn't even be a liability of the company.
So it would be significant from an insolvency perspective.
It would be an extremely different outcome from an insolvency perspective.
It would be radically different from an insolvency perspective. And we'll come on, it's also very different from a tax perspective. But before I make that point, I mean my second point, which is that it's also odd because you end up amending the bit of the tax code which the Court of Justice has said is okay, namely Section 80, is odd. And we've got from the Supreme Court in FII SC3, for your note, tab 68, page 2134, paragraph 142, that you expect to go to the bit of the tax code which is the source of the EU law problem when you're doing your conforming construction. And third point, and this relates to the oddity from a tax perspective of this, is that by allowing the tax charge to kick in after exit, you are jeopardising the balanced allocation of taxing rights. The whole point of the balanced allocation of taxing rights is that the tax charge is supposed to kick in at exit, and you're not after exit when it becomes more and more difficult to tax. And perhaps the insolvency example is a good illustration of that point. Another illustration of that point is that the imposition of a tax charge on a non-resident entity is, well, to put it mildly, unorthodox from the perspective of the UK approach to taxation. And there is an example of it which has been done recently in relation to property development in the 2016 Finance Act, but for it to be done by a court would be really quite unorthodox. And point 4 is that we say that it would be the alternative conforming construction which is advanced would be contrary to a fundamental feature of the legislation, namely that the exit tax is imposed at the point when the trustees cease to be resident. It seems to us that probably is a cardinal feature of the legislation, because that's what makes it an exit tax. And finally, we say that it would be less, and this is my fifth point, it would be less consistent with the grain of the legislation than the construction that we've suggested, which focuses just on payment. And you see that from sections 280 and 281 of the TGCA, the dry tax charge instalment provisions. So for those 5 reasons, we respectfully suggest that ground 3 shouldn't be accepted. And that takes me on to block 4 of our submissions, which I can take quickly, because I'm conscious that the appellants will be wanting to start their reply submissions. And that's in relation to disapplication. Now, as Lord Bridge explained in Factortame, the position under the European Communities Act 1972, sections 2.1 and 2.4, is that where you have disapplication, statutes are to take effect as if there were a provision in the statute stating that the provisions of that statute are to be without prejudice to the community rights of nationals of member states. And this is well explained by Lord Walker in Fleming, actually. If we go to tab 45, page 937 of the bundle, I can read what he says. This is paragraph 24. Where a disapplication is occurring, the provision is not made void, but must be treated as being, as Lord Bridge put it in Factortame, without prejudice to the directly enforceable community rights of nationals of any member state of the EEC. So that's what you're doing, and this ties in importantly to the EU law principle of proportionality, and we see that from the Colstaff judgment, which is in tab 71 at page 226. So this is Lords Briggs and Lord Sales, who were agreed with by all the other justices. So it's not a Fleming type situation. And they talk about proportionality at paragraph 83 as a general principle of EU law. So this is paragraph 83, page 2246. And they say that the use of EU competencies is governed by the principle of proportionality. And Article 5.4 of the EU Treaty states that under that principle, the content and form of union action shall not exceed what is necessary to achieve the objectives of the treaties. As Giger, that's a learned law academic, particularly emphasises as one aspect of the principle of proportionality as a general principle covering the relationship between the Union and Member States. It is in accordance with this general principle that, when giving effect to individual rights under EU law and providing an effective remedy in relation to them, inconsistent rules of national law should be disapplied only to the extent necessary to secure compliance with those rights.
I'm so sorry, Mr. Patel. Which paragraph are you reading from?
Paragraph 83, page 2246.
Thank you.
So the disapplication, it's an aspect of the principle of proportionality that disapplication only occurs to the extent necessary to secure compliance with EU law. And Mr. Elliott pointed out, as he went through Mr. Justice Henderson's judgment in Prudential, that Mr. Justice Henderson noted that if he disapplied, it wouldn't have been surprising that he would have ended up with the same outcome as on a conforming construction. And we see a very similar point made in Vodafone. I'm not going to take it to you right now, but at paragraph 66, it's tab 47, paragraph 66, page 996, Andrew Morritt there refers to the possibility as an alternative of disapplication. And he specifically says that he would have taken a great deal of persuading to just completely disapply the CCF legislation, and that rather he thinks the suggestion is that the more likely outcome would have been disapplication only to the extent that there was a non-compliance with EU law, and specifically in that case it was to the extent that there wasn't genuine economic activity being carried on. So we've got strong suggestions that it's quite common to end up with an outcome under a conforming interpretation which is similar to the outcome which you would end up with on a disapplication. Now what we say is that in this case, disapplication would simply mean going through the payment obligation and identifying a way in which that payment obligation could be disapplied only to the extent necessary to ensure compliance with EU law. So you don't escape from the EU law, the difficulty of grappling with EU law by having disapplication. It's not a situation where you can just kind of put a line through the UK legislation. You still have to identify as a court the contours of what is required by EU law, and that, we say, is the best answer to that is payment by instalments. And so that would mean that you would disapply the payment obligation so that it kicks in instalments. So that you end up with essentially the same outcome, but without a conforming interpretation. I'm going to pause for a moment there because I was proceeding quite quickly.
But is that disapplication or reconfiguration?
Well, it is because it means that the statute which imposes the payment obligation is disapplied to the extent that it requires payment earlier than EU law than is compliant with EU law.
But by hypothesis, you haven't been able to do a conforming interpretation here. Otherwise we're not into this.
Yes.
This is an alternative submission.
Yes.
So you haven't got a conforming interpretation which says pay over 5 years.
Yeah, correct.
By definition.
Yeah.
So what have you got? Well, you've then got a statute that says pay all at once, because that's all you're left with. So I must say I find it impossible to understand how, if you disapply that statute, you end up with an obligation to pay over 5 years?
Well, so say for example that the obligation imposed by the statute was to pay £5, and the effect of disapplication is that you can only disapply the statute to the extent that it's inconsistent with EU law. We know that if the payment obligation imposed by that statute is to pay £5 immediately, that's inconsistent with EU law. But if it's to pay £1 in year one, another £1 in year two, another £1 in year three, and so on and so forth until the tax is paid off, then that's not inconsistent with EU law. So you're then disapplying the obligation imposed by the statute, namely the statute, but only to the extent required by EU law, as opposed to just saying, oh, well, you don't have to pay there's no obligation to pay at all, which is further than what EU law requires.
So you're saying that EU law is going to the mechanism and not the substance, because you can have an exit tax.
Yeah, yes.
And accordingly, in effect, by this mechanism, you're saying you haven't managed to do a conforming interpretation, but in effect, because you don't just strike through the exit provision, the substantive provision, you're only concerned about payment. I won't say timing, because that, that brings in all sorts of other things. Payment. In effect, you imply terms which would be, you do it the opposite way. You say you don't impose or anything which is more than you need, but as you haven't got anything at all, you're in effect implying, aren't you, what you haven't been able to make by way of conforming construction.
Well, what you're saying is that there's no operative payment obligation imposed by the statute.
And so you're
insofar as it doesn't. I mean,
isn't that just a conforming interpretation?
Well, so it is different, because if so, for example, if the conclusion which the court arrived at was that there was a cardinal feature of the legislation which was violated, which meant that a conforming interpretation couldn't be arrived at, then you still wouldn't be prevented from disapplication. So disapplication is not subject to the requirement of some sort of cardinal feature requirement because of the section 2.1 of the ECA. So in those circumstances, I do suggest that you can arrive at an outcome in which a payment obligation is staggered, i.e. it's not applicable in its totality on the 31st of January, but it's applicable as to £1 on the 31st of January and so on and so forth.
So it's a payment obligation that revives annually.
For a fifth of the amount.
It becomes applicable over time. Anyway, I don't want to labour the point, because it doesn't seem that I'm necessarily getting a great deal of traction.
To that way.
And I should also say that Mr. Elliott has obviously already addressed the question of interest, which is actually also relied on by Panayi. I think the only other thing is that I think there are a couple of questions which Mr. Elliott was asked, which
I've got 2 points. I've been handed a note. Firstly, is a correction to the date that Redevco paid. It was the 15th of November 2021. And the second point was in response to the question of Justice Miles about the reference to Schedule 25 in Vodafone.
I think that was actually...
Sorry, yes, reference to Schedule 25. We can't find, there was an implicit that was suggesting there was some sort of power to amend in Schedule 25.
Yeah.
We can't see that, but
Right.
there is actually a power in Section 748 itself for the commissioners to expand the exceptions.
Oh, right.
So I don't know what the reference was to 25, but there was a power in the legislation to make the amendments.
Thank you.
Thank you very much indeed. Mr. Johnston.
Well, can I have the lectern? My ladies, my lord, I've agreed a division of labour with my lady friend. Don't worry, it's fine. Whilst I'm being passed the lectern, if I could hand up what may be one of the least exciting hand-ups you've ever received. which is the multilingualism policy of the European Court of Justice. I suspect I won't come to it, but whilst we're doing furniture removals, I might pass it up. I'll only come to it if I have time.
Thank you.
I'm very grateful. So I've agreed a division of labour with Mr. Margolin. He's going to deal with PPCN, he's going to deal with interest, and I'm going to deal with the other points. And so I may go slightly past halfway in our time because there may be a slightly larger number of points for me to cover. In my time, I propose to work through the respondents' blocks of submissions. And at each point, I'm going to seek to identify the core issues between us and identify what is, in my submission, the proper response to each issue. And then I have a couple of sweeping up points at the end if I have time. So coming to block 1, Mr. Fell's submissions in relation to the EU case law, there are 2 core questions in my submission to determine arising out of those. And the first issue, under this heading, I think is summarised as, is the provision of a choice or a chance to choose a necessary or critical feature of the EU authorities? And in my submission, the answer to that is yes. And the very simple positive case is that you have seen the word choice or choose all through all of the cases that you've been shown. And Mr. Fell offered 4 reasons why choice is not a cardinal of the EU case law on exit taxes. First, he said that the recurrent use of that word was a hangover from N and the inspecteur. The language is just being repeated in all of the AG's opinions and judgments. It's caught on as a phrase, but you shouldn't read too much into it or place too much weight on it. The difficulty Mr. Fell faces with that submission is that the word choice or choose does appear in each and every of the judgments you've seen, and the court will be very slow to conclude this is some kind of linguistic reflex. Rather, my submission is that the point goes the other way. The court cannot ignore that wording because it is repeated. Quite the contrary, its recurrence makes clear how central it is to the court's reasoning. Second, he said that choices might matter in cases to do with deferment until realisation, but not so much in cases of deferral in stage payments. We say that's squarely inconsistent with the authorities he showed you, DMC, Verda Labtech, cases about staged payments that specifically mention the need for choice. And just to pick up NGI, briefly if I may, which is at tab 88, I try not to go to too many authorities because of time. Tab 88, page 2912. Paragraph 73, the point that the court is making there is that these are choices about cash flow. And the question of the phrase cash flow, as you've seen, recurs all through the cases, including the later cases. The exiting party, rather, has to have an option to choose. They are choosing, in the case of payment in instalments, between paying interest and smoothing out their cash flow, or paying up front, and if I can put it colloquially, taking an immediate hit. That is a commercial decision, and that is the choice that the court repeatedly insists must be offered.
Is there any case, Mr. Johnston, in which there was an issue about lack of choice, other than the simple point that you couldn't pay in instalments?
Yes, Melanie, many of the cases that are referred are cases in which there was an immediate obligation to pay, and what the court says is that that is disproportionate because there is not a choice. There must be an option to choose at the point of departure. So that's all through the authority. So DMC at paragraph 64, Verda Labtech, all of these cases, that's the kernel of the proposition that I'm relying on, which is the cases go to the court saying, in some cases, there's been no option to defer at all. And the court says, well, no, you must have a choice. In the other cases, even where the question is this method proportionate, the court comes back to the concept of choice. And it says, it is proportionate because there is a choice.
Suppose you have a case of instalment payments, 5 years.
Yes.
But with the right just to prepay the whole lot at any stage.
Yes.
what would be the difficulty there? I mean, you're making the point about, oh, you've got to worry about interest and so on, but it's hard to see the revenue ever saying, oh, we don't want the money. You carry on spreading it out over 5 years.
That would be a question, I presume, for the revenue. I don't think it forms a part of their proposed conforming interpretation that is something that, partly consistent with their suggestion, it must be very simple and very straightforward. Certainly not part of what the tribunal below found. But in that circumstance, you would have the choice, and that would be consistent with the cardinal and the case law, which is that at the point of exit, you have an option or an option to choose specifically. And so in the example you're giving me, you'd have an option to choose to spread it out, and at a certain point you may choose, because of cash flow reasons and commercial reasons, actually I want to pay the rest of the sum now. And EU law would say that scenario, I anticipate, I don't think that precise scenario is being referred, but EU law would say I anticipate that that's fine, because you have the choice.
Isn't this in a sense wrapped up in the retrospective nature of the conforming interpretation? And as Mr. Elliott was submitting, if you look at the facts of prudential, they're even more extreme. No knowledge of the ability to do what you could have done, and that's not an issue.
So my own friend's going to be doing with PPCN, but just to crystallise an answer to that, the difference in PPCN is that is not a case in which EU law has said you must have a choice. And that is why this case is like Fleming, to anticipate my submission on Fleming. In Fleming, must be foreseeable. And so what my learned friend has said is Fleming's different and it's special, it's in a different box, because limitation periods must be fixed in advance. And my submission is that this is a Fleming case, not a PPCN case. Because this is a case in which it is at the core of the EU law right in question and the EU law principles that there must be a choice. So you're absolutely right, my lady, it does go to this question about foreseeability, and it comes to my core submission, which is that Mr. Margolin is going to deal with, or has dealt with, retrospectivity more generally. My case is that this is a particular kind of retrospectivity, and it bites differently. So I lean on, if I can put it that way, Mr. Elliott's submissions from Fleming, and say that this is another case of that kind.
I see.
And therefore, that's where it fits analytically into the picture.
That's helpful, thank you.
The third point that Mr. Fowler relied on was the translation of paragraph 60 of the Advocate General's opinion in Panayi, and there was a suggestion that the best reading of the judgment by reference to a Google translation of the French and German is that Advocate General Cocotte meant to say that this could possibly all be solved by conforming interpretation. First very brief point on that, I won't take you to the language policy, but the language of the case is English. It doesn't stop other language versions being something you can rely on, but if there's no conflict between them or ambiguity, the authentic language of the case or the authentic version of the judgment rather, is the judgment in the language of the case. And you'll find that in the handout that I gave you. But in any event, the argument as I understood it was that there may have been a reference to the possibility of conforming interpretation in one paragraph of an AG's opinion, and that is enough to give strength to your arm as a court to do what you're being encouraged to do. And I do say that is a very thin basis for a very wide submission. It's not picked up by the Court of Justice. We don't see it anywhere else in any of the other cases. It is not easy, in my respectful submission, to reconcile with the overall thrust of these cases, which is simply to say, this is unlawful. This is in principle how it could be made lawful. It is a question for national courts, what they do. So I do say in my submission that is a submission that should not detain nor persuade you. Fourth, Mr. Fell's submission was that the court's referring to a legal right to choose, not what he called either a diffuse right or today a full-blooded right. And I understand that submission to be that what the law requires is a theoretical or a formal right, but not an actual right to choose in the real world. We do say that is very difficult to square with the authorities because the concern within the case law is about the real world choices that businesses or persons, or in this case trusts, make at the point at which they move across borders. And so the submission that this is a case where you can say, well, there's a legal, the PPCN point, to come back to my ladyship's point, that you can say, well, actually, in that case, in PPCN, they did have the right, and there was also functionally the opportunity to do so. They could exercise the right, they just didn't know at the relevant time how to do it. We say that is different, radically different from this case, and we do say that the case law insists on a real choice, not a hypothetical or a theoretical one. So in conclusion on this point...
Why is it different?
Why is it different to PPCN?
The Court of Appeal said that on a retrospective conforming
Yes.
interpretation, they had a right, but they didn't know about it, and that was tough.
Yeah.
Why is that different from this case?
Because EU law doesn't, in that case, place the right to choose at the centre of it in the way that it does in this case, and that's why this is a Fleming case and not a PPCN case. Because this is a case akin to Fleming, where in Fleming the scenario is it must be fixed in advance. In this case, the wording again and again and again of the court is you must be able to exercise your choice at the point of departure.
But that may be the nature of the EU right. So once we know what conforming interpretation is, you've got a right to make a choice at the point of exit.
Yes.
But the effect of the retrospective effect of the conforming interpretation on the facts of this case is a separate point. So it may in fact deprive you of the choice, but that's just an inevitable. It is like prudential. It's an inevitable consequence of the retrospectivity of the interpretation, isn't it?
Well, Panayi, I don't want to go over the point
No.
too many times, but the thrust, the kernel of the submission, is that this is a particular kind of retrospectivity. It's squarely accepted that the ordinary process of conforming interpretation is retrospective in effect, and that may have, in some cases, unfortunate circumstances. My submission is that this is a different kind of case, and that's a submission I was making on Tuesday, and I'm making it again today. And that's because this is a different kind of EU law right. EU law is insistent and recurrent as regards the necessity for choice. And in those circumstances, we say it is not possible to vindicate that EU law right by way of a conforming interpretation that means that that right can't be vindicated. And that's why, but that's the same thing too many times, that's why it's akin to Fleming. Because in Fleming, well, it must be, the limitation period must be set down in advance. In this case, the option to choose must be available at the point of departure.
Yeah.
And so we say that this is a case in which, because the human act of choosing by reference to commercial factors that concern the court in the judgments is absolutely critical, that's why we say that this is a case which is different to some of those that you've been shown. I'm mindful that Mr. Margolin's stressing PPCN, but I'm finding myself doing so. But I'm grateful for the question.
I see the way you put it.
I'm very grateful. Turning to the second question, under this head, do the authorities establish an irreducible minimum requirement of compliance with EU law? And the answer to that, in my submission, is no. So Mr. Fell asked himself the question, what does EU law require? And he said, deferral, I quote, deferral in 5 equal instalments will suffice. But that begs the question, why? What's the basis for that? Why does it suffice? And why doesn't deferral until realisation, in particular, suffice? And at no point in his submissions did Mr. Fell point to any passage in the Court of Justice authorities where the court came even close to saying, this is the irreducible minimum, this is the basic, this is the point that is the minimum EU law requires, and you go no further. The closest that I could see from what he was saying in his submissions was when he relied on ATAD. But he accepted that ATAD wasn't in force at the time, it doesn't apply to trustees. The more fundamental point is that ATAD is an EU-wide harmonising directive. It reflects a political compromise between 28 member states, the Parliament and the Commission, each of which will have pursued their own priorities and objectives in a complex process of negotiation. It cannot possibly be suggested that ATAD offers a definitive statement of the best fit, or more importantly, the minimum that EU law requires. So in my submission...
But surely that's a question for the domestic court to analyse. It's not a question for the Court of Justice to decide what is the minimum. The Court of Justice may make some observations, but when the domestic court applies a conforming interpretation, is for the domestic court to say, well, what's the minimum that's required in this case?
Well,
Or have I got that wrong?
with respect, my lady, I think the question what EU law requires is certainly a question of EU law.
Yes, but the minimum,
therefore,
discerning what the minimum is surely a question for the domestic court.
well, my lady, with respect, I don't accept that proposition. I would say that it is going to be a question of EU law to decide where the perimeter sits. And if, for example, we had had a judgment where a case had gone to the Court of Justice and they'd said, we've got deferral for 3 years, and the question was, what's the minimum? And the court had said, well, we think 3 years is the minimum, then you would know the minimum vis-a-vis deferral in stages. But the core of my submission is that there is no principal basis on which to determine, nor in my submission has any been offered to you, what is the minimum required by EU. We've been told that it's deferral in 5 years because we know we've had 2 cases, one about 5 and one about 3, albeit we don't know the minimum, but we've had those 2. And you're being encouraged to proceed on the basis...
Sorry, which was the 3?
We haven't had a case about 3. No. Sorry, I may have misspoken.
I thought you just said...
No, my apologies,
Sorry.
I must have misspoken.
No,
We've had a case about 5 and a case about 10, and we haven't had a case about a smaller period. My apologies, Marlon. You're being encouraged to proceed on the premise that there is a minimum. And in my respectful submission, there is no solid basis, no principal basis, no tool being offered to you by which to determine that. And in my respectful submission, it is not at all obvious that deferral in 5 equal stage payments is a minimum, whereas deferral until realisation is it goes beyond that in some way. I simply don't accept the proposition, but nor, with respect, do I know precisely how to attack the submission, because I don't fully understand the premise of the submission at the moment, which is how does one make that choice? Answer, at the moment, it falls under the heading of assertion, and that's precisely what the Upper Tribunal did. And I showed you that on Tuesday. They simply decided that it was a minimum, but they didn't explain why it was a minimum. So my submission, the answer to the question, is there an irreducible minimum that the court can identify and decide not to go beyond, is you get no hope at all from EU law, and my first submission is that would be where you would need to get it from. But in the alternative, in answer to my lady's question, there is nothing that provides you with a solid basis for making that determination. How would one choose what is more or less out of a 5-year stage payments or 5 years of deferral? Or, I mean, there's just no principled way of cutting through that problem. And so I do say that there is no irreducible minimum the court can identify and not go beyond.
One of the points that was raised was whether is what you mean by deferral until realisation. And do you have anything to say in relation to that? Do you mean the charge doesn't arise, or the charge arises on exit but is not payable until
Well, it depends whether I'm in ground 1 or ground 3 is the answer to that question, my lord. So for the purposes of ground 1, all I need to persuade you of is that a model whereby the asset is assessed and liability arises at the point of departure and then it's deferred until disposal is an option which is no greater or lesser, goes no further or less far than EU law requires. That's all I need for ground 1. Ground 3 obviously is different, but for this stage of the analysis, that's my submission. I hope it's relatively clearly articulated. That leads on to block 2, the law on conforming interpretation. It's common ground that the law provides that the court should not make policy choices that are properly reserved to Parliament. There is a question about precisely what is properly or not properly reserved to Parliament, I think it's fair to say. And that's the core question. Are the choices before you of a kind that you should not make? And my submission is that the answer to that is yes. Now, the first plank of my learned friend submissions is that, and I put this colloquially because I'm summarising, but that this is not too much of a constraint. And that was a submission made by reference to paragraph 59 of Vodafone 2. And it may be worth turning that up. It said Authorities tab 47, paragraph 59.
47.
47. I think I do need to turn it up given the submissions I'm going to make about this paragraph. And it's in particular the words, it's on page 994. It is the case that there are likely to be other ways of achieving conformity, and the choice of one rather than the other may well involve policy decisions. But if that consideration alone could render a conforming interpretation illegitimate, it would considerably restrict the occasions in which a conforming interpretation could be adopted and lead to an increase in disapplications. I'm going to deal with the final sentence in a moment. I do say that this paragraph is rather difficult to square with some of the other leading authorities on this point. That particular part of that paragraph, and in particular, if I can, for your note, encourage you to read Guidan, that's Authorities, tab 41, page 881, paragraph 33 by the little c on that page. You'll see the same point about making policy choices in Ample Award, at tab 70, page 2218, at paragraph 99, and also for your note, the judgment of Lady Justice Arden in IDT, at Authorities 43, page 885, at 89. And in my submission, the principle that the court cannot engage in choosing between different policy options is a very well established one. And it is not at all easy to reconcile that particular sentence with the wider thrust of the authorities. And so in that respect, I recognise that Vodafone, particularly obviously the famous paragraphs in 37, 38 are very widely quoted, but the suggestion that the court can take policy choices, I do say, is difficult to square with the case law. His second submission is that you could make a policy choice that would otherwise be for Parliament if it goes with the grain of the legislation. And the first response to that is an obvious one, which is that if it really and truly goes with the grain of the legislation such that we know what Parliament would have chosen, there may be no policy choices at all to be made. All we're doing here is reflecting what we know Parliament intended. But the second part of the answer to that is that that's not this case, because the conforming interpretation being urged on you does not go with the grain of the legislation. The legislation makes no provision for a delay of this kind in relation to exit taxes. It provides for realisation at the point of departure. And the core of the submissions at this point was that by reference to sections 280 and 281, that reading in what is being urged on you now goes with the grain. As to that, those provisions are wholly different on the mechanics. They work differently. They are to do, at least in the case of gifts, with a taxpayer who has lost control of the asset, so the underlying logic and policy purpose of it is different. That is not this case. They have no relevance and pay no regard at all to EU law. They are nothing to do with leaving the jurisdiction, so we say there is no relevant analogy here. And at that point, it's also worth, I think, picking up on my learned friend's reliance on Vodafone and Prudential. So my learned friend says that they're examples of going with the grain, and he says that this is a case that's about going with the grain as well. But they're not the same. They concern the addition of either a new credit or a new exemption in a long pre-existing list of similar credits or exemptions. Huge long schedules, indeed, of exemptions. That's not this. What we have here is HMRC casting around within the UK legislative regime and finding something that looks a bit like what is being urged on you, but in a very different context. His third point was that choices can be complicated, but this is not a complicated one. And in that context, if I can put it again colloquially, and I mean no disrespect, the submission was, fear not, this is not as complicated as FII. And therefore you can make this conforming interpretation. But again, FII is not a case like this one. In that case, there was a choice before the court between two parties both advocating for different conforming interpretations. This is a case about HMRC's conforming interpretation or disapplication. The parties are not coming to you with two schemes and saying pick one. And you will recall, I hope you have noticed it, but if not, that at paragraph 111 in FII at page 1698, part of the reason for rejecting HMRC's solution was because it involved the making of a scheme. And I'll come back to that in a moment. That leads me to the fourth limb of my learned friend submissions, and you take that, I said I'd return to the very end of paragraph 59 of Vodafone 2 if you still have it open. The choice of conforming interpretation which faithfully follows a conclusion of the Court of Justice, as in this case, does not, in my view, trespass on the forbidden ground of legislation. This is not a case in which you know, coming back to my earlier submissions under Block 1, what the Court of Justice has told you you should do. And if Advocate General Cocotte or the Court had said, this is the solution in the UK statutory scheme, or this is the irreducible minimum that EU law requires, then that would be one thing. But the Court of Justice and the Advocate General in this case, and in others, have offered absolutely no indication about how the UK might choose between different kinds of solution. They've identified the interference.
Well, they can't do that, can they?
No, indeed. But what's being said here, and what's being relied on at the end of paragraph 59, is the suggestion that you don't need to choose if you can faithfully follow what the Court of Justice has told you you can do. And the simple point I'm making, perhaps over-elaborating, is that that's not this case, again. And in fact, the first-tier tribunal judge was pretty candid about that. The first-tier tribunal judge had a list of options, option 1, option 2, option 3, option 4. And we do say that that is consistent with our submission that what you have at the end of paragraph 59 there, which was a core part of what underpinned my learned friend submissions, you know what EU law requires, so you don't have to choose, we say is not this case. The second topic in block 2 related to the making of statutory schemes. There is a dispute between us, which I hadn't anticipated, about whether there's a rule against making of schemes by way of statutory interpretation. Mr. Elliott says that really that's just a feature of the rule about going with the grain of the legislation. The short answer is that such a rule has been articulated clearly multiple times in the authorities. And the question then arises, obviously subsequent to that, is this a scheme? And my submission in relation to that is yes. But just to give you the references, Guidan, you've already seen the reference to a scheme, FII, paragraph 107 on page 111. And at paragraph 107, so that's at tab 59. Sorry, I've misread my own reference. It's at tab 59, page 1698, and the references in the paragraph numbers are 107 and 111. So there's a reference. 111.
Thank you.
So there's the reference there to introducing a scheme. The reason we don't do this is we don't introduce a scheme, and that's the reason HMRC's is rejected. Finally, also in Vodafone 2, and seeing as I have it open, I may as well turn it up briefly. Lord Justice Longmore's short judgment, final sentence of paragraph 17, nor can the process of interpretation create a wholly different scheme from any scheme provided by the Act. And he cites Lord Roger at paragraph 70 on page 996. So we do say this is really rather well established as a proposition. And what it captures in reality is the principle that there's a point beyond which the interpolation of a sufficiently substantial change goes beyond what the court should do. And I recognise that there's a slightly imprecise boundary there. I was asked on Tuesday what the definition of a scheme might be. And I confess my first answer in my head was, if it walks, quacks and swims like one, it'll be a scheme. But I'm not sure that's very helpful to the court.
Well, it echoes something that Lord Steyn said in one of the cases that we've looked at today, where he used the similar, if I may say, cliche of
yes.
The elephant.
Yes.
And being something that it may be difficult to describe, but everyone knows when they see an elephant.
See it.
And that may be something of a cri de coeur in that it's actually not. He said he'd gone through a whole series of cases which he set out in the schedule in that case.
Yes.
He said it was very difficult to define the dividing line, but one knows when one's across it. And that it looks as though when the courts are talking about a scheme, what they mean is you're on the wrong side of the line.
Well, that may be right, my lord. I'm going to attempt.
It's an elephant.
Maybe your ladyship and your lord will not welcome the possibility of trying to bring some definition to it. But just to assist genuinely if I can, two touchstones. Firstly, the nature of it. Does it go beyond merely redefinition, reading out or reading in of a word or phrase, but lead to the addition of something substantial and novel? And secondly, complexity. Does it involve a series of stages or parts rather than only one element? I hope that's helpful. It may not be helpful. It may be that we're better off talking about elephants or ducks. Briefly, in relation to Fleming, which you have at tab 45, you really have the core of my submission on Fleming, which is that this is a Fleming case, and I'm not going to repeat that having already made it. The second point is that the question has arisen about whether Fleming really applies in this context. Is it a case just about disapplication? If I can just address that briefly. Yes, the court said that it was a case about disapplication, but it's important to recall what the issue was. The court had to either disapply the new regulations entirely or disapply them by reading in a new transition scheme. So the reading in would have been, these provisions are disapplied to the following extent. And so that's why when the judges are talking about filling a regulatory lacuna and so on and so forth, what they're doing is something remarkably similar to the process of conforming interpretation. It's actually precisely the same reason why in my submission my learned friend's respondent's notice point doesn't work. Because in those circumstances, disapplication and conforming interpretation are two sides of the same coin. So we do say that Fleming is squarely on point because it's grappling with an analytically very, very proximate question. And in those circumstances, we commend to you all of the paragraphs that you were taken to on Tuesday. I won't go back to it. So that brings me to the question, is the measure a scheme? Might be worth turning up what the tribunal found. If you would like, it's at Paul Mundell, tab 82, page 141, paragraph 141. You've seen it before. It has a gateway provision, only if you're moving to an EU member state and your free movement rights are going to be interfered with. It then has an option. So there is an option that has to be exercised in some way. And then mechanics for payment. And coming back to my typology for a scheme, it has multiple parts. It involves more than Gaidan and Godin Mendoza, which I know I accept is one particular kind of example. It's more than just reading a word in a particular way or even reading in a particular word. There is a structure here. There is a mechanism. There are multiple moving parts, and we say that it's a scheme. My third point to respond to here in relation to retrospectivity, I think you have the submission already. First, it turns on the question of choice in the Court of Justice case law. I won't go over that again. That is a cardinal of the case law. And then the question is, does the conforming interpretation give the appellant a more than hypothetical option or choice? And the answers to that seem to be, A, well, they have exercised the choice because they haven't paid. I can assure the court that my clients feel rather strongly about that submission. Certainly from their perspective, they've not exercised the choice to take the benefit of deferred payment. Rather, they've identified an unlawfulness, they've challenged that, they've won on that point, and now they're being told that it doesn't matter because the statute, which was unlawful, is now going to offer them by conforming interpretation a choice that they could never have exercised at the time. So we do say, by reference to the submissions I've already made to you, my clients have not exercised a choice to defer, they have challenged in law, and they cannot be given that choice now. That leads me very briefly to ground 3. You already have my submissions on this. It's always been, as you know, in the alternative, and that is that whether or not the sum is quantified at the point of departure, and that's something within the case law as I took you to on Tuesday. It can be, it doesn't have to be. And again, this isn't a question of going beyond or not going beyond what EU law requires. These are just options. Then the better conforming interpretation is that the liability to tax arises at the point of disposal, whether quantified at the point of departure or otherwise, and that's because it's simpler, because the assessment to tax and the obligation to pay would kick in at the point of realisation at the same time, tied together like the scheme now. So so consistent with the thread of the scheme now. And thirdly, we say it would be a less substantial amendment. I have 1 minute on ample award. So I think I'm saying differently to my learned friend, but that probably means that he's saying it right and I'm saying it wrong. Can I ask you just to turn that up briefly?
I think you're right, actually.
I think you're right, yes.
And I say that partly because I was in the Upper Tribunal in that case, and counsel for the company called it ample award. So we have a fair
Horse's
authority.
mouth.
I'm going to say that I'm enormously grateful, and that's excellent news. If I could ask you to turn to page 2218 again.
I'm sorry, I'm lost. Which?
Oh, sorry. Yeah, I think I may not have said it. It's tab 70. If I did, I said
Tab
it.
70.
70. Can I just encourage you to read again 99? I know you were showing this not long ago. And of course, what we in particular rely on are the words, that is all the more so, where there may be several ways in which legislation may be made compliant, which involve policy choices which a court is ill-equipped to make, and then the reference to Guideline Lord Nichols. So we rely in particular on that. You've seen the reasons that it was refused in that case. First, because the words in any member state are clear and unambiguous. Of course, the court is giving a series of cumulative reasons. It's absolutely right. The court is not saying here that because the words are clear and unambiguous, we can't do it. That's not the thrust or thread of the judgment. And that's the beginning of 101. Then at the end of 102, just over the page on 2219, whether Parliament would have chosen to do that in a case in which excise duty is not payable, may never become payable, is an open question. Indeed, Parliament's response might even have been to abandon the optional exemption completely. This is the core of the reasoning here. Starting point, this goes against the thread of the legislation. It goes against the words directly, rather. Okay, not enough on its own. But in this case, we just don't know what Parliament would have chosen to do. And what's interesting about it is he does know what Parliament did do in this particular case, but that doesn't mean that he's entitled, Lord Justice Lewison is entitled to engage in the intellectual exercise of presumption, if I can put it that way. And then down to 106, you'll see the nature of the amendment that's being sought. It's to replace any member state with the United Kingdom. And just to take one point that we picked up on Tuesday, this would be a case of making conform to what we know EU law requires in the VAT directive. So therefore you would think a simpler case, but Lord Justice Lewison is not prepared to replace any member state with the United Kingdom. I do not consider my leasing principle entitles a court to adopt an interpretation which is in direct contradiction to the words used, moreover, specifically contemplates a warehousing regime, and so on and so forth. And then we come down to the very end. The suggested conforming instruction would have retrospective effect, although Parliament has expressly decided that it should not. And a submission has been made, or the suggestion has been made, that my learned friend answered a question to the effect, well, we'd all be here anyway because we just challenged that because that's also unlawful. 2 points on that. I actually don't think that is what my learned friend said, but I'll leave him to correct the record if he wants to. Secondly, that isn't, of course, my submission at all. And thirdly, it would be irrelevant in any event to the question of conforming interpretation. The question for the court is not, can we wargame an alternative way in which this dispute arises in a different forum? The question for the court is, or a different form, the question for the court is, can you, by way of conforming interpretation, make this amendment? And what's being said here is that not a factor which must weigh sufficiently heavily in the balance on every occasion that it overwhelms all other factors, of course, but a weighty factor is that Parliament has thought about this point, has had the option to give it retrospective effect, and didn't. So you know Parliament's intention as regards the temporal scope of the solution, inverted commas, in this case. Well, I'm not going to address the respondent's notice at all. I had one point that I wanted to make, which was in relation to the question that had been asked about Section 2.1 of the European Communities Act. I just wanted to clarify the record, if I can find it in my note. Yes. Just for the purposes of the judgment, of course, Section 2.1 of the European Communities Act doesn't apply anymore. It's been repealed by Section 2.1 of the Withdrawal of EU Law Act, of UA 2018. So Section 4 of UA has repealed it, but has retained its effect in certain respects. Section 4 of UA has itself been repealed by Section 2.1 of the Withdrawal of EU Law Act, but Section 22 of that says that it still applies as regards anything occurring before the end of 2023. I've probably done that much too fast, but the only point I wanted to make, my lady, is I was mindful that we'd all been talking as though Section 2 was live and on the statute books and operating in its normal way.
No, obviously we know that it isn't, but because of the date when all these things happened,
Then
we have to behave as though...
Precisely so, and I just wanted to make sure that the court, for the purposes of your judgment, had the relevant route
Even
through.
I've been awake.
My lady, I didn't mean to...
No, it's fine.
We're grateful.
I'm very grateful.
Very helpful.
Unless I can assist any further, those are my submissions.
Thank you. Mr. Margolin.
I always seem to end up with the graveyard slot.
We're all ears.
Well, I'm hoping to be very brief because as Manana from Mr. Johnston trailed, I'm just going to respond to two areas of Manana from Mr. Elliott's submissions. The first is in relation to interest. I addressed you on interest yesterday and took you to what I had hoped were some of the milestones in terms of the statement of the revenues case in relation to this, including the transcripts of the Upper Tribunal hearing. I'm going to return, I'm afraid, notwithstanding the phrase from the Book of Proverbs that rings in my ears when I say this, to some of those milestones very briefly. But before I do so, can I just start by respectfully reminding the court what the conforming interpretation adopted by the First Tier Tribunal and the Upper Tribunal was. And one can get that either, of course, from the decision of the First Tier Tribunal, which is perhaps behind tab 8, but perhaps most easily from the decision of the Upper Tribunal behind tab 4 of the core bundle, volume 1, at page 61. So right at the top of page 61, within paragraph 64, the Upper Tribunal referred back to what Judge Brooks had held was the conforming construction to be applied to Section 59D of the Taxes Management Act, which was therefore to be read as follows. Corporation tax for an accounting period is due and payable on the day following the expiry of 9 months from the end of that period, or, in cases where the taxpayer's right of freedom of establishment would otherwise be infringed, in 5 equal annual instalments following the end of that period. So I just pause to note that on the First Tier Tribunal's conforming interpretation, which was upheld by the Upper Tribunal in our case, is when, in circumstances where EU law rights bite and the freedom of establishment would otherwise be infringed, corporation tax is due and payable in 5 equal annual instalments following the end of the relevant accounting period. If one then goes, I hope, my ladies, my lord, very briefly, to volume 1 of the authorities bundle, I recognise the wording in the case of the Panayi appeal is slightly different, and one has the benefit of what Mr. Bremner said on the transcript about how EU law rights impact on that analysis in Panayi's case. But so far as our appeal is concerned, if one goes behind tab 5 to page 59 in Authorities 1, what one sees there that the provision of section 59D1, I'll just pause a moment, the provision of section 59D1, which is being subjected to that conforming interpretation, provides that corporation tax for an accounting period is due and payable, those are the words I emphasise, on the day following the expiry of 9 months from the end of that period. So it's that provision which, by virtue of the conforming interpretation adopted by the tribunal, that's what's extended. If one then goes forward to the following page, page 60, please. one sees that Section 87A1 provides that corporation tax shall carry interest at the rate applicable under Section 178 of the Finance Act 1989 from the date when the tax becomes due and payable in accordance with Section 59D of this Act until payment. Now, it may not be a submission to be made in this forum for all the reasons that have been mentioned, but not perhaps fully explored in relation to jurisdiction. But one can see how a very easy interaction between Section 59D and Section 87A suggests itself in terms of how interest would operate here. And in my respect for submission, that is clearly not only what the tribunal had in mind, but what my learned friend Mr. Elliott had in mind in his submissions in relation to interest before the first tier tribunal. Because, and you were taken to this yesterday, I'll just give you the reference for now. In the first tier tribunal, so this is supplementary bundle tab 11, page 109, and its internal pages 93, 94. Mr. Elliott was submitting to the tribunal, you don't have to say anything about interest, one, because of the jurisdiction point, but secondly, because if you don't, actually the interest will flow from this anyway, because interest runs from the date of payment in Section 59D1, and that comes from Section 87A. If you said nothing about interest, which is what we invite you to do, interest will run from the date of each instalment. And as I say, it may not be a submission for this court, but there seems to be, in my respect for submission, a lot of force in that. And the point is taken up again in the transcript, same tab at pages 110, 111, which is internal page 40. Now, I mentioned that so far as our appeal was concerned, we made a point in a footnote in our skeleton, although it had seemed from the Commissioner's response to the Trustees' notice of appeal in Panayi that actually what had been said by Judge Mosdale specifically in that case about interest was being disputed. That clearly wasn't the point that was available to the Commissioners in our case. And so far as the Commissioner's skeleton of our case is concerned, and the reference is footnote 9 on supplemental bundle tab 15, page 179, we took it that there was no point being taken in interest in our case. But in any event, even as regards Panayi, as I mentioned yesterday, and the reference here is supplemental tab 23, page 288. In the revenue skeleton in Panayi, they said that applying Section 86A of the Taxes Management Act alongside Section 59B conformingly construed, if an instalment payment wasn't made upon the required date, interest would run from the date upon which the instalment payment fell due. And that's a point which we've seen was reiterated, as my friend Mr. Elliott put it this morning, certainly as the Commissioner's primary case in Mr. Bremner, King's Counsel's oral submissions. Now, as I say, we looked at the transcripts yesterday, and you were taken to certain passages this morning. One can see that there was some discussion between the tribunal and Mr. Bremner as to how interest should work. That, of course, in circumstances where one of the issues it was being said needed to be considered was, well, what would the ramifications be? To what extent do you need to write in a scheme that deals with things beyond payment date? But the Revenue's primary position remained that you didn't really need to do anything about it, and that if you applied Section 86 alongside Section 59B, conformingly construed, if an instalment payment wasn't made on the required date, then interest would run from the date upon which that instalment payment fell due. And if one looks, again, I'm not going to ask the court to do it now, but if one looks generally at this discussion at pages 192, 193 to 194, and 197 of tab 16 of the supplementary bundle, one can see how those discussions proceeded, but it's important to note, this is supplementary bundle page 191, Mr. Bremner's primary position when moving on to the question of interest was the principle that the other provisions of UK law apply alongside section 59B, conformally construed. That gives the answer. There's his discussion, which relates more to the Panayi appeal and the Panayi wording at page 192, internal page 14. And then at the bottom of page 193, internal page 20, this is an important point in my respect for submission, Mr. Bremner's King's Counsel says, you know, the appellant is saying you're trying to invent a new scheme. What I'm dealing with is my response, actually. No, I'm not inventing a new scheme. There are provisions about interest. There are provisions dealing with things that they say need to be dealt with. So going back, I think, to an observation my Lord made, perhaps it would be helpful in circumstances where there are other matters that interact with how a conforming construction works. But perhaps it would be helpful in certain circumstances for a tribunal or court to state its understanding. But of course, in our case, that's not what it was being asked to do. It was being told specifically, you don't need to do that. You don't need to import a scheme. You just employ the conforming construction.
As I understand this point, you're really saying that I think that actually the revenue took a forensic stance on this, because it was no doubt in its interest to say, oh, you have to do as little as possible to fiddle around with the existing legislation. So, and since the existing legislation deals with interest, it's all there, so don't worry about it. Whereas if you were to seek to come up with an outcome where interest is payable from day one, the instalments are payable, you'd have to do more.
And you have to therefore unravel the first tier tribunal's conforming interpretation or add to it, which is not what the upper tribunal was being invited to do. And one does then have to engage with a situation which is rather more complex, in which there are rather more moving parts than the revenue submission was. Your Lordship's put it more elegantly than I'm
But also, I think you're saying that in your case, at least, the decision of the first tier tribunal was as recorded in paragraph 64 of the UT's decision. That was a passage you showed us. And there wasn't an appeal in respect of that.
Absolutely. And so we say, with all due respect to the upper tribunal, it's unfortunate that in relation to our case, there was any real going over of matters in relation to interest, particularly in circumstances, and I recognise that Malone Friends has taken you to passages showing that there was some discussion about all of this, but without the revenue ever resiling from their position, either in relation to the conforming construction or generally that they weren't actually pressing or pushing the upper tribunal to do anything differently in respect of interest from what the first tier tribunal did, which is precisely nothing, because Mr. Elliott's invitation to the first tier tribunal as well was you just don't need to say anything about it, it will follow naturally. And what that means is it will follow from the dates of each instalment where the conforming construction is operative. It's unfortunate, with respect, that the upper tribunal got into that at all, because it recognises, and one sees this from paragraph 150 of its decision at page 84 of the core bundle, they say, we therefore do not need to concern ourselves with such matters such as the provision of security or the payment of interest, as these are not issues in the scheme of UK legislation at the time of the migrations that breached the appellant's EU law rights. We note that UK domestic law already provided for the provision of security for companies migrating out of the UK, and Section 86, that's obviously in relation to the Panayi appeal, Section 86, Taxes Management Act, makes provision for the payment of interest, which is my Lord's point about swerving any need to justify the importation of something looking more like a scheme, because actually it was all very straightforward, and one simply had the interaction of the conforming interpretation with freestanding, self-standing legislative provisions. And I would simply add a couple of points without wishing to give evidence. One is that my learning from Mr. Elliott sought to suggest, when discussing what happened in the Upper Tribunal by reference to the transcripts, that the question of interest was very much live when Panayi came before the Upper Tribunal, that it heard full argument over the course of 2.5 days. And I think his phrase was that HMRC squarely run this before the Upper Tribunal. My respectful submission is that's not something which is really borne out by the transcripts, and it's certainly not borne out by the documents setting out the parties' respective positions in relation to interest, in relation to either appeal. By the time one came to the Upper Tribunal, certainly not in respect of my client's appeal. I hope that's all I need to say for now on interest. And in terms of what our substantive position on interest is, you've heard my observations in relation to Section 59D, Section 87A, learning from Mr. Elliott's submissions. I mean, essentially our position is, even if the Upper Tribunal is right in saying that the conforming construction in Panayi goes further than was required in relation to interest because there was a specific reference to interest, it didn't say anything about that at all in my case, and in any event, with respect, it rather misses the point. The tribunals chose to implement EU law by conforming construction, providing for payment in 5 instalments. The conforming construction is then done, although the choice of conforming construction has consequences in terms of how it interacts with other, as I've called them, freestanding provisions. And as a matter of domestic law, it triggers domestic provisions which, on their proper construction, we say, provide that interest is payable only once each instalment becomes due. That's
what seems to me to be significant on this, I don't want to go on too long about interest, is that the conforming interpretation they come up with, that the FTT came up with in your case, actually tracks the words of the section, not surprisingly, in not just saying it's payable, but saying it's due and payable. And that's the statutory form of words which is used in 59B and D, and then it's picked up again in 86.
Certainly 86, certainly 87A, which is
the interest provision.
I think 86 may talk about the relevant date, so the wording slightly.
But the one you just showed us again refers to the idea of it being due and payable. Because if it just said payable, one might think that there was a distinction being drawn, but it says due and payable.
That's a distinction which, with respect, had occurred to us, but it's not one that is material for our purposes because it isn't there. It exactly tracks what's said in Section 59D, Section 59D1. In terms of PPCN, you already now have the benefit of my learning from Mr. Johnston's submissions, and I'm simply going to confine myself to a few additional remarks, if I may. The first is that, as my learning from Mr. Elliott put it, I think specifically with reference to the discussion in paragraphs 39 to 42, in a sense, we're not seeing anything we haven't already seen in the case law. But in my submission, PPCN needs to be considered in context. You've heard something about that already from my learned friend, Mr. Johnson. It was a very different and very complex case arising out of the FII litigation where non-UK dividends were being treated differently from UK dividends in breach of EU law. And it concerned the making of protective claims in respect of past transactions to protect the taxpayer's rights to repayment of tax. My first observation is that's very far removed from Redevco's case, which wasn't concerned with procedure and a failure to make a proper claim, but with what we've described as a momentous transaction carried out on the basis of legislation that was, at the time on its face, defective. And one sees at paragraph 6, so if perhaps it's helpful just to turn up tab 76 while I make these points. So that's volume 8, tab 76. And it's at page 2403 at paragraph 6. So 2403 paragraph 6, Lady Justice Falk says, in broad terms, the taxpayers in these appeals seek to rely on their statutory rights under the tax legislation as interpreted to conform with EU law requirements to generate tax refunds or reliefs as an alternative to common law claims and restitution. The disputes largely but not exclusively concern the applicable procedural mechanisms. And then the two overarching points running through the various issues listed in paragraph 14, paragraphs 13 and 14, forgive me, are at paragraph 15, which my learned friend took you to. And those two overarching points were first, the extent to which the interpretation, sorry, this is 2406, the extent to which the interpretation of the procedural regime should be approached in a manner which ensures that taxpayers secure all the benefits to which they would have been entitled under an EU law-compliant tax regime, even though they were not aware of the precise nature of their rights before the time limits expired. The second was about the consequences of the conforming interpretation of the DTR regime required by EU law and how far that went in terms of benefits available to taxpayers. If one then goes to the following paragraph, one sees that those points were said to be reflected in the way the taxpayers expressed their grounds of appeal. And those grounds of appeal one sees at the bottom of 2406, top of 2407, and are said to reflect the overarching points mentioned above. The court's treatment of ground 1, the overarching principles of EU and ECHR law, begins at paragraph 26, so that's the bottom of page 2410. And the question essentially was whether or not a conforming interpretation should involve the reading in of an extension of time into procedural provisions of domestic law on the basis that the taxpayers had, so they said, done all they could to claim double tax relief, but hadn't known they should do so by a particular procedural route. And so they argued that that offended against the principle of legal certainty. One sees that at 26 and 27, where Mr. Bremner, King's Counsel, in that case appearing for the taxpayers, his argument in essence was that the taxpayers' claims were wrongly being denied by reliance on a failure to meet conditions that weren't notified in advance. So the basic point is that this is all to do with the making of a claim and with remedies, and hence the importance of the principle of effectiveness, which, as one sees from Lady Justice Falk's observation at paragraph 43 at the top of C on 2415, she considered to be the principle at the core of the taxpayer's case. And on the same, in fact, on 2418 at paragraph 55, point to note is that this wasn't just about the bringing of claims, it was about the bringing of statutory claims, and the significance of that is touched on in 55 on 2418. Statutory claims must comply with the legislative provisions applicable to them, subject only to any modification required to ensure that those provisions comply with the EU law principles already discussed. Key reasons we say why this is a completely different situation from ours. You've already had, from Mr. Johnston's points. I would simply add these additional remarks. First of all, as one gets from paragraph 45, this is on bottom of page 2415 over to 2416. It was always open to the taxpayers under the legislative regime to make a claim for double tax relief. They just didn't know that they could or should do so. But as the court recorded at 45, the procedural rules applicable to claims for DTR have remained materially unchanged throughout the relevant period. It was clear throughout how long taxpayers would have to make a claim and how it could be made. There's nothing comparable, for example, to the limitation rules considered in Viciano, where key aspects of the rules had either not been fixed in advance or had been subject to a change in approach by the national court. And then right at the bottom of the page, to the extent that Bellet or Gil San Juan are relevant at all. The right to claim a DTR credit was clear on the face of the legislation, could straightforwardly be exercised, and has not been affected by any retrospective change in approach. So the court's making there the point that the relevant procedures have been clear throughout. Section 790, always containing provision for the grant of a credit. That's the opposite, we say, of this case, where there wasn't any provision for deferral. The whole deferral regime is a new invention. Now, HMRC would say that the prudent course of action would have been for the taxpayers to seek to make timely claims by every means, including Section 790, and also common law claims which would have been available up to a certain point of time when the law changes, one gets from paragraph 55, but which they didn't bring. And just finally in relation to that, in paragraph 49 on 2417, right at the bottom of paragraph 49, it's at C in the margin, it says, while HMRC may not have accepted a claim for DTR if one had been made, it would have been open to a claimant to assert the validity and effectiveness of the claim through an appeals process. My point is a straightforward one. There's no such option here. Redevco had to decide whether to make the commercial decision to migrate, from which there was then no going back, and the only thing it could do was to consider the position, take advice, and decide whether to migrate or not. And can I also just mention very briefly, for your note on the transcript, what's said at paragraphs 44 and 50. In 50, it's recorded that the taxpayer's position was that a conforming interpretation went before a conforming interpretation of 790, that the conforming interpretation required to remedy the breach of EU law. The court rejected that submission, rejected the submission. Any further conforming interpretation of legislation was required. We say all of that's very different to this case. Here the argument isn't a plea from the taxpayer seeking the addition of a new route of procedural challenge or extending time by conforming construction. The boot's on the other foot. The revenue, in fact, want the court to read in a new statutory scheme. And then I think finally, going back to paragraphs 41 and 43, in those paragraphs in the discussion section, Lady Justice Fout repeats the general points about retrospectivity previously made in Vodafone, IDT, and FII SC1, and you already have the appellant submissions on that. That's to say that a conforming construction is by its nature retrospective, and to that extent doesn't interfere with legal certainty or here effectiveness. And I've already acknowledged what's said in those cases about there being, as in any legislative interpretation, an element of retrospectivity. The key distinction between our situation and ordinary legislative interpretation and the declaratory theory of judgments is, as I said before, that issues of legal certainty are more likely to be engaged, and the fact that the approach to conforming construction must therefore be subject to the important proviso that the interpretation adopted doesn't cross the Rubicon and stray beyond the proper boundaries of interpretation. And that wasn't an issue in PPCN because Mr. Justice Henderson's interpretation of Section 790 didn't involve any significant rewriting. It consisted in a modest extension to an existing statutory regime by removing the denial of a credit for portfolio dividends. And we say, therefore, it falls squarely on one side of the line rather than the other, and well within the established bounds of judicial intervention in the case law. And to that extent, in terms of legal certainty, the claimants can properly be taken to have known in deciding whether or not to claim that was the appropriate procedure. But we say that the position here is very starkly different. Unless I can help the court on anything else, those are my submissions.
No, thank you very much indeed. And thank you to everyone for their very, very helpful and clear submissions, and to everyone behind who has no doubt done an enormous amount of work in this case. You'll be extremely relieved and pleased to hear that we're going to reserve our judgments. And you will know the usual procedure in this court. Drafts will be circulated for for the correction of typographical errors, but not re-arguments, thank you. And we hope that you will be able to agree a consequential order, and if not, that you will make very short written submissions in relation to it, and we'll decide on the papers. I ought to also remind you about the embargo on those drafts when they go out. We're extremely grateful, and thank you both for your written and your oral submissions in this very interesting appeal.
All rise for the table.